Hello, my name is Georgianne Ford with the Alpha Center for Divorce Mediation. And today we have one of our attorney mediators, Mike Ruth, returning to us on a topic about frozen embryos and marital property when going through a divorce. So Mike, this is an interesting topic we don't hear much about. So tell us what we need to know.
Hi, Georgianne. Good to be with you again today. Just a random topic that came up in a conversation that I had with some clients, and it's not one that you always hear about. And so I actually did some research into it and found out a couple ways, here in Pennsylvania, on how they deal with this topic of how frozen embryos get handled in a divorce situation. So first, I had to kind of get a background on how and why those are created, and then basically how they get looked at. So basically, if you go through this embryo process, this in vitro fertilization during the marriage, then this property becomes marital property, right? So it's the same thing as any other asset or debt that we own during the marriage. So it gets viewed as marital property. Therefore, in a divorce, it's considered part of that division, that equitable distribution that we go through. So in
I don't think any of us ever think of that as marital property. So just clarifying that off the top.
Right. I think the idea would be that it would be the property of the female, where the eggs actually came from. Mm-hmm. But that isn't the case. It is viewed as being our property as a result of the marriage. So I found out a couple different ways that it's looked at. Here in Pennsylvania, there's one case from the Pennsylvania Superior Court that kind of laid out their decision on it, and it was actually it was heard back in 2012. So there really hasn't been any recent court cases around this subject, which I also found surprising. So so I delved into that a little bit in this decision that they came to. Basically, the situation was the wife had a medical condition that was going to prevent her from procreating in the future, and she basically wanted the embryos. The husband didn't. So normally the court said that the first thing that they would look at would be if they had a contract from basically the time that they were frozen, that would determine how they were going to be distributed. And since there wasn't a contract, they decided to look at basically a balancing approach in this case. And
is it more standard? Sorry, Mike. Is it more standard to have a contract than not have a contract?
I think, Georgianne, that kind of clears things up. Why there hasn't been too many cases on this, going forward is my understanding is that when you have these embryos frozen, that the facility asked you to draw up a contract at that time that kind of sets out what's going to happen in certain cases. And I think they covered divorce in that contract. So that kind of eliminates the need for any discrepancies. But there wasn't a contract in this case. So they used a balancing approach, basically looking at best interest of each parties. And since the wife had a medical condition that was going to prevent her from conceiving in the future, they awarded the embryos to her. So Pennsylvania has this balancing approach. There was also mention of a contemporaneous mutual consent approach that some states have used. But that was basically both parties coming together and making a decision at the last minute. And the Pennsylvania court thought that, if they were able to do that, then why would we be in court anyway? So that was kind of, put to the side as far as a way to look at this. So, really at the end of the day, I think the recommendation that the court made on after their decision was that to clarify this and to prevent you ending up back in front of us, you need to write a contract at the time that you have these frozen. And then that was basically what came out of this.
You know, it makes so much sense. So what I think I hear you saying is, even if the facility doesn't require it, you're recommending definitely a contract.
Right. And that's what the court's decision said. You know, outside of, you know, the fact that we have used this balancing approach based on best interest of each party, the idea is you need to take care of this by writing a contract that establishes what will happen in case of a divorce, in case of this situation. So
I'm guessing that if in fact that happens, it's going to be pretty rare to get to have to deal with this with the marital property part when you get
right. You know, it's a unique subject. You know, something that I hadn't been confronted with before. You know, like I said, I thought there would be more cases out there on this, but it sounds like that recommendation to draw up this contract is the standard nowadays. So maybe it eliminates any confusion going forward. But I thought it was a unique subject for what we normally talk about, and that's kind of why I introduced it today. I'm not sure if anybody had discussed this before, and so if it comes up again, you know, we now know what to do in case.
Absolutely. I mean, we can't walk away without thinking you got to have a contract. It just makes total sense, and this isn't something you really want to deal with when you're going through a divorce.
No, probably not, because there are a lot of emotions involved. So.
There are so many emotions. Mike, thanks so much for just bringing this to our attention. If anybody's out there and hearing this, they are for sure making sure they have a contract or going back to maybe get one drawn up to make sure that doesn't happen. If any of you have questions about this topic for Mike, or you just want to have a conversation with the Alpha Center for Divorce Mediation, please give us a call at 1-800-310-9085.